it was remarkable that the section itself was not referred to. In fact, for that reason, because of that, the section was then misrepresented in all sorts of ways. But if the court allows me just 5 minutes, really to step back for context. Well, Leonard and Mr. Badlander, for the first accused, or the applicant in the first in the Downer matter for Mr. Downer, says that Mr. Downer is not here to assert any constitutional right. And that's why he says, well, he doesn't understand why we talk about to bring to a court of law any dispute that to bring to a court of law any dispute that can be resolved, I'm paraphrasing, by the application of law. Any court of law, whether it's this court or the criminal court or whatever, or the labor court, or whatever, or the labor court, the purpose of that submission doesn't matter. That's why we're here, at least speaking for ourselves. And what has that got to do with the Constitution? What is this thing called private prosecution? Some students from UNISA jokingly said to me, now you've started this private prosecution. When we do criminal procedure, everybody just went through it because you knew that there would be no question asked about it because it's so rare. But now we have brought it into the public domain, as it were. Well, for the education of those who don't know, a private prosecution is not those who don't know. A private prosecution is not any game. It is probably one of the cleverest inventions of any legal system. You'll find in Dutoy, because of time I won't go through it, but there's a section on private prosecutions that goes back to, you'll find it in the very opening part of the book. I think it's 1-3. The right to private vengeance. They did so on the tacit understanding that the state would dutifully prosecute crime. And then it goes on. Is meant to inhibit us from our natural instincts to hit back. An eye for an eye. So you take in that example, former President Zuma is supposed to say, what? You take my medical information, you take information that belongs to me, you leak it to the media, without the permission of the NDPP. When we report that to him, he's supposed to say, where are those people? I want them here now. I'm going to show them. Where do they live? And seek private vengeance and go and do whatever he thinks will ameliorate that injury to him. But no, the law and our forefathers had a better idea. They said, no, former President Zuma, you don't have to do that. First, You must go to the police station and on your behalf take over that anger that you have. And take over that anger that you have and do with it what the law says it should be done. And then you should be fine. It was the wisdom of the ancient. But it goes further. It says, but former President Zuma, in the event that the state refuses, for whatever reason, good or bad, to then act on your anger, you have a conduit called private prosecution, through which you now may prosecute. So still don't go and beat up the people or whatever. You should... well, my lord, it might be well known to this court, my lord, but I'm not only addressing this court. This is, that's what I'm saying. This matter is, the context is very important. Yes, okay. But that's fine. Well, okay. Well, then it means we are in the area that we were fearing. Yeah. That's fine. Okay. Where am I going with this? Let's go to section 41.6 now that the court understands the purpose. Because we are told, in fact, the court is with the context is unfortunate, because the what Ndumeni tells us is that we must, when we are interpreting section 41.6, look at the context. And not only look at the context, look at the purpose. That's what we call purposive interpretation. So if we are not to canvass the purpose of section 41.6 in the context of this case, that's fine. But let's at least, or even the purpose of section 7 of the CPA, which the reason why not this, the Constitutional Court and the Constitutional Court and the SCA favors this contextual and purposive interpretation is because otherwise everyone can just come in here and say, okay, let's look at the mechanics. Section this and A and B and C and D and this and what, without understanding what really we're here about. But that's fine. Now let's go then to section 41.6. Or let me pack that. I'll tell you, my Lord, where we're going to find some of these things in the papers. These papers are difficult to navigate because there's the Downer volumes and the Karyn Maughan volumes. But I'll try to, as much as possible, to guide the court. Now, unfortunately, I have to go back again to the issues of the first preliminary point we raise, of course, is a matter of jurisdiction. And then the second point that we raise, which is related to that, is prematurity or ripeness. Of jurisdiction. And then the second point that we raise, which is related to that, is prematurity or ripeness. And then we raise the issue of the, only in respect of Mr. Downer, the authority of the state attorney to act, and then the joinder or non-joinder point in relation to the non-joinder of Maughan. But the big points are the two. Jurisdiction in this context is very important, because once again, why are we here? Motion court in front of 3 judges. Those 3 things are important. We're in the civil court, we're in the motion. Court, and we're in front of 3 judges. That's another issue. I know we don't want to go to context, but it's another issue that needs to be taken seriously. People don't know that it's not a fashion statement that a judge in a criminal court wears red robes, and the judge sit, and then other places where other people sit. So it's even different buildings. Why is that? Because the constitutional founders, in their wisdom, decided that criminal matters must be decided in the criminal courts and civil matters in the civil, and at the risk of telling the court what it already knows, and civil matters in the civil, and at the risk of telling the court what it already knows, of context. That distinction is not contrary to what was said in the President Zuma. That distinction is very serious. You can't just say a court is a court. No, it doesn't work like that. And that is why in the criminal court, for example, if this matter had been raised in the criminal court where it should be, there is no possibility whatsoever that you could have it heard by 3 judges. Because criminal trials, as we know, are heard by 1 judge wearing red for a good reason. And that's where the rub is. Is it permissible? Should it be allowed in our system that you have a criminal matter and then you say, no, just wait a little bit, my lord. I'm just going next door to the civil court to ask them to set aside this prosecution. I'll come back. I'll see you later. Imagine if all accused in this country, every month, the greatest news we've ever had, that we can actually stop this magistrate or judge and go to the urgent court, Nokal, and stop what is happening there. It's bizarre. So the first thing is that the criminal matters should be heard. If you don't believe me, then you can at least believe His Lordship Mr. Justice Wallace, Moyo case that your lordships have. Let's start at paragraph 169. Yes, no, let's start at 157, I'm sorry. 157, your lordships will be familiar with that case. The facts, I'm not going to traverse them to save time. He said, and this is where the subsidiarity point, which was completely misunderstood, starts. He says, the appellants do not seek to impugn the provisions of the CPA, Criminal Procedure Act, in any way. They are seeking to assert their fair trial rights before a civil court, as happens here. That should give pause for thought. Why are issues germane only in the context of criminal proceedings being canvassed and determined in civil proceedings, and not in the constitutionally compliant forum and in accordance with the constitutionally compliant statute provided for the adjudication of criminal cases? He asks us as a rhetorical question because he then goes to answer it. But let's mark just the rhetorical. He says it must cause a pause for thought. Why are issues coming from criminal context being adjudicated in civil proceedings, where the legislature of this country has determined that it should be in the criminal court? And when you are not attacking the constitutionality of the CPA, then you are forced to apply that statute. That's what subsidiarity means. If you are not, unless if you are attacking the constitutionality of the Criminal Procedure Act, then you must abide by it, whether you like it or not. If you don't like it, then you must attack its constitutionality. And he says, the appellant's response to this question is to say the Constitutional Court has held in Savoy that they have standing to bring the present proceedings. Savoy involved confirmation proceeding where the Constitutional Court was obliged to accept jurisdiction. So that shows that this is a jurisdiction point. And then he says at 158 further down, the concern in this case is that it has been done outside. I'm sorry. He says here, at an appropriate stage and in appropriate proceedings. Please underline that. At an appropriate stage and in appropriate proceedings, because that is going to arrive when we talk about prematurity and all that. Which is the only place where the constitutionality of legislation is an issue. It is an abstract challenge, and as Madlanga J. rightly said in paragraph 13, courts generally and rightly treat abstract challenges with disfavor. Again, it's just another fancy tag, abstract challenge. It simply means challenging something, effectively challenging something's constitutionality, but without attacking the actual constitutionality of the, outside of the Hande case, which I'm sure the court knows about interpretation. Yes. Then he says at 169, which is really what we have here. The trial has not commenced in that case. It is commonplace to see in the media that the first step in any criminal proceeding, in any criminal litigation involving a prominent person, is that they will challenge the constitutionality of the charge or the process leading up to the commencement of criminal proceedings, which is what's happening here. The term Stalingrad defense has become a term of art in the armory of criminal defense lawyers. And then here's the rub. It says, by allowing criminal trials to be postponed pending approaches to the civil courts, justice is delayed and the speedy trials for which the Constitution provides do not take place. I need hardly add that this is of particular benefit to those who are well-resourced and able to secure the services of the best lawyers. And then he says that all of this, the question in every case, I'm at 170, is one of the interests of justice. That's really the test that you must apply. In my view, the interests of justice in both of these cases demanded that the High Court decline to hear them before the resolution of the criminal trials. And His Lordship basically was saying, to paraphrase, that courts should not hear these types of matters unless if there are exceptional circumstances. And we've made the point numerously in our heads that no exceptional circumstances have been pleaded here, or it has not been shown any, the interest of justice is not even mentioned, which is the only test really. So the court cannot just on its own invent the interest of justice when the people who have brought the case here have not asserted it. And actually one of them has said he's not here to assert any constitutional rights. The tea. How long? Yeah. Okay. No. No.
Yeah, I'm going to move over. Yeah? As mina ngithunyiwe. Oh, bathi immediate 24. Bangibonile.
Ukhuluma ngayo le time. Athi mina ngimazi nami.
Oh, ile.
Mafakele manje. Bathi hayi. Mina bengathi already sebazi ukuthi sebakubonile baya.
Man.
When you span, I don't understand what you span.
I'm having your muffin there. We're gonna actually. All these instructions are what the word is. I hope they don't know. Yeah. Otherwise, it's all
Recording
the
in
team that
progress.
worked on this in the Synergy project in phase one, Gen Z is not just a one size fits all. And that's what your research is telling you. So don't try and find a one size fits all, then, play that back to your stakeholders and make them aware that Gen Z is not just a mass solution and that they do need to cater for different markets. Yeah. Question is, how big are those markets? Yeah.
Yeah, I totally agree. I reckon you could develop maybe four personas within Gen Z. That would actually be really nice to present at the first stakeholder review, is to show how you've segmented that whole category in alignment with the jobs to be done.
Yes.
Exactly. Yeah.
Yeah.
See, Ollie, I need you. I can't be so succinct. I'm like going wide again. And then Ollie says it in one sentence. Thanks, Ollie.
I'll send you this article that I found, because it really helps embed this, what the principle is of the personas, and gives you the different categories. So it basically asks you to draw up a bio of each type of person within Gen Z. So I think that'll help. You can put a little one pager around who this person is versus that person within that one category. And if you show that at the framing presentation together with how you're going to leverage those jobs to be done into your how might we question, that would be brilliant. And then you can ask for their input as well from the stakeholders, which one of these do you think we should focus on, and get them to help you prioritize them.
Exactly. Yeah. Because remember, they're the ones essentially paying for it. They're your customer, right? They're your client, rather. So, if they say, well,
purpose of a special plea is, after all, to make sure that we don't spend money on some long trial which might take years, if indeed it was fatally flawed. But this court said we were wrong. This court said not only were we wrong, actually that matter should be raised at the end of the trial. So it can be wrong then and right now that one comes here prematurely. That's not justice. That's just playing with the law. And there's a big difference between a court of law and a court of justice. If it is justice that we seek, then we have to ensure that justice is blind. It doesn't matter whether today former President Zuma is the accused or the prosecutor. The same rules must apply. That's why we're here. But no, he was told, no, you must raise it at the end of the trial. And that decision, mind you, was affirmed, as Mr. Badlander said, by the SCA twice and even by the Constitutional Court, in the sense that leave to appeal was not upheld. So I was counting that means 15, a minimum of 15 judges hold that view, that there's nothing wrong with a 1061H, nothing wrong with a 1061H issue being raised at the end of the trial. Forget even about the beginning or the bleeding stage. So that rule must be applied here. Unfortunately, this court has no choice in that. Secondly, this court also has no choice. It is bound by the utterances of Wallace J.A. that I referred to in the Moyo case, because that's a Supreme Court of Appeal of 5 judges. And if it's good enough for Wallace J.A. to say a matter that is that should be determined in the constitutionally preordained forum, then it should be good enough for this court as well. But this court is even bound by the Constitutional Court judgment in Tint, which we have referred to in, I think these are the Downer papers at page 361. And ironically, this was also cited or quoted with approval by Kun J in this court, saying this court should discourage preliminary litigation that appears to have no purpose other than to circumvent the operation of Section 35. Generally, disallowing such litigation would ensure that the trial, and I added my own brackets, the criminal trial, to ensure that the trial court decides the pertinent issues which it is best placed to do, and would ensure that trial starts sooner rather than later. Of course, there can be no absolute rule in this regard, but in the ordinary course of events, and where the purpose of the litigation appears merely to be the avoidance of the application of Section 35(5) or the delay of criminal proceedings, all courts should not entertain it. So, I said page 362 of the Mr. Maughan, sorry. I'm sorry, it's the Maughan papers, yeah. That's what I was saying. It's our answering affidavit. We quoted this case even in the answering affidavit because of its importance. I'm sorry, but I can give the correct reference, my lady. It's Tint Pty Ltd versus National Director of Public Prosecutions and others, Zuma versus National Director of Public Prosecutors and others. It's 2009-1, SA, page 1, decision of the Constitutional Court, my lady. Thanks. Thank you. And I think the passage I was reading from appears at paragraph 64. Let me just make sure. Yes, it's paragraph 64 of that case. And it's quoted, as I say, with approval in the judgment of this court in the State versus Zuma before Judge Kuhn. And as I say, the Constitutional Court did not mince its words here, and it was not diplomatic. It says the court should not entertain. such a thing. Now, we are told in this court, and even in the wrongly decided matter of President of the Republic of South Africa versus Jacob Zuma, which was in January 2023, the one that was relied on. What was actually said there is startling, to say the least. And that's why that, firstly, that case should not even be referred to here, because it was a matter dealing with interim interdict, which has its own special rules. As we all know, an interim interdict, you can even interdict something that's happening in an arbitration. It doesn't presuppose that the second court, so to speak, has jurisdiction. It simply says that the court has jurisdiction to stop whatever the calamity that is feared. So that case is actually completely irrelevant to what we are busy with today. But to the extent that it can be relied on, we associate ourselves with the, again, basic rules of stare decisis, which mean that case is not binding to this court because it's from a different province. At best, it's persuasive. And it would even be more persuasive if there was a single judge here. But now there are 3 judges versus 3 judges in another province. So this court is not bound by that. It wouldn't be bound by it anyway. It would be persuasive. But what is worse is that even if we were in Gauteng, that court would not be binding because it's clearly wrong. Insofar as it wishes to pit the SCA, for example, with some 1950 case in the Transvaal before a single judge, and which is the case of Solomon. But if you have to go to that case, you go to paragraph 5, and I won't read. That's where they quote 157 of Moyo, which I've already quoted. And then it says at paragraph 6, on the other hand, there is clear authority to the contrary, that a party who is charged by a private prosecutor may indeed approach a civil court for relief as is sought, and then it relies on Solomon versus Magistrate of Pretoria, 1950, bracket 3, in the Transvaal. Pre-constitution, single judge, in the previous era, and then the courts do say that that case was applied in Van der Venter, which is another provincial matter, and in some place called the Southeastern Cape, I think, local district, in the case of Netco versus Belishana. And then here in Nandandal. But Nandandal is a different kettle of fish. Nandandal is a review application, which is actually brought, I think, in terms of Paja. So there is no constitutional court equivalent, let alone SCA equivalent, that can countervail Solomon's case, rather Moyo's case and Tint's case, which are binding to this court, unlike being merely persuasive. So the gist really of this is that what's good for these accused persons, or any accused person, by the way, in the whole country, anyone, even someone who's appearing for stock theft somewhere this morning, if they have a problem with the matter, they must raise it in that criminal court, and at the right time. So the next submissions, therefore, in limine, assuming the court somehow finds a way around Moyo, Wallace J.A.'s utterances and Langa, CJ's utterances in Tint, then would be the issues of the other issues that we raise, namely the state attorney's right to act in the case of Mr. Downer. Now, we are told here that the only answer that you are given is to say no. If you are raising that thing in terms of Rule 7, then you should have done it at a particular stage. And you should, therefore the court must not entertain it. In other words, even if it's a good point, the court must simply not entertain it because it is raised late. Well, I have two answers for that. The first one is that even if you wanted to play those technicalities, one cannot escape from the fact that the real issue that is being raised is the applicability of the State Attorneys Act, which is the only legal basis, at least that we know, in respect of which a private prosecutor can prosecute. There's a case of in the SCA, which happened recently. I think my learned friend, Mr. Stephen Badlander, was in it. We were together in it at some stage in it. And that was the case where the issue to be determined, I'll give the citation now. The issue to be determined was whether the state attorney should pay for Mr. Zuma's defense in criminal proceedings. Now again, it looks like when the shoe is in the other foot, the rules suddenly change. Because two things emanated from that case. One was that the fact that that point was raised late in the SCA, I think for the first time, did not deter many years after the proceedings had started, and there was an awareness issue and so on. But the second one was that unless there is authorization for the state attorney to act in criminal proceedings, which obviously prima facie attached to the person personally, then the state attorney, then Mr. Zuma, it was said in that case, should pay for his own defense. So what does that mean? It means once we've raised this point, all that the other side should have done really is to say, no, there was authorization in terms of the State Attorneys Act, and here it is, and Mr. Zuma, we don't know what you're talking about, because the state attorney is entitled, or a power of attorney if it was a private attorney. It's very simple. You say, no, but here, how can you say Mr. Ntanga here should not act for Mr. Zuma, because he has the power of attorney. But we know that in terms of Rule 7.5, the state attorney is exempted from having to produce a power of attorney. So that point, I will not take it further than that. If we understand the defense to be saying, don't raise it now, you must raise it in separate proceedings, which are specific to attack the mandate of the state attorney. Well, maybe that's what will happen. But we thought it would be better to, since we're here, to raise that issue. But if that is the dilatory plea that is being presented to us, because the point is not going to disappear. The taxpayers' money is being used to defend the private misdemeanors of Mr. Downer. Then the other point which we raise is the non-joinder of Ms. Maughan. Now, this might look like a trivial point, but it is not. Remember that, firstly, this court refused to consolidate. We actually wanted a consolidation of these matters, which would have gotten rid of that point. And the court refused to consolidate for whatever good reason. So these matters, although for the sake of convenience are being heard together here, they are separate matters. So it is open to say that Ms. Maughan should have joined Mr. Downer. She says in her own affidavit, my co-accused is Mr. Downer. So I've never heard of a situation where an accused person, in fact, even in the Section 106 matter that we raised here, the representatives of Thales, unfortunately for them, had to be here day in, day out as we were dealing with that matter. Why? Because they had nothing to do with the 106. They were only a party to this simply because, and they had to fly from Joburg every time we argue the matter, simply because they are accused number 2. They have an obvious interest in the matter. But now we hear something novel, new law. We are told that Ms. Maughan has waived her right to be joined. I've never heard of such a thing. If she is has to be joined by law, not a joinder of necessity, not a joinder of convenience, as that expression is used, then she must be here. So I can't say, for example, I'm suing this department because they didn't give a particular tender, but one of the winning bidder says it's fine, you can do it without me, and therefore that means that I should not have joined them. They are mixing up two different things. If the person says, I wish to abide, that's fine. We can't force them to come to court. But as to whether you should have joined them when you were starting your proceedings, there can be no debate. Even a first-year student would know that that's a joinder which you must make. And that's the issue we're raising. So Mr. Downer or Mr. Maughan, Mr. Downer did not know prophetically in October that one day in 2023, Ms. Maughan is going to waive her right, unless there's other issues that we don't know. And so that subsequent waiver cannot be a cure to the actual failure to join. Let alone the fact that to the extent that they seek to rely on Nandalal, the decision of this court, then it makes the non-joinder point even more serious. Because remember, if you are doing that, you are then actually setting aside the decision, in the case of Ms. Maughan, of the official who issued the nolle prosequi, and then in the case of both of them, of the registrar or official who issued the summons. But none of those people have been joined. How do you begin to review or set aside the decision of the clerk of the court or whoever it is, who issued the nolle prosequi, or even the National Director of Public Prosecutions, who issued the nolle prosequi, and or the magistrates, clerk of the court or the registrar of this court, who issued the summons in their absence, without them even knowing. They'll hear one day that, oh, that administrative act you performed in September last year has been set aside. They're going to say, what? What are you talking about? Nobody cites them. And for that proposition, you don't even have to go far. You must just go to the front page of the case, the Gauteng case of President of the Republic of South Africa versus Zuma. We there, because we were contest, or rather, we were the prosecutor. Let's say we were the NP, the private NPA. Were joined with a second respondent, the Director of Public Prosecution of KwaZulu-Natal. That's because she had issued the nolle prosequi. The NPA, for obvious reasons, and the Registrar of the High Court, because they had issued the summons. And that's why those people were essential, unless if we're going to be told that they've also waived, quote unquote, they've waived their right to have their decisions set aside in their absence. a strange phenomenon. But that's fine. Let's assume all of those can be overcome somehow, which I don't know how. Then we come to the merits of the challenge. Now here, I have to differentiate it like this. Sorry. As I said at the beginning, I'll deal with the issues that are raised by both of them. And I'll try to do it in such a way that I start with the non-points, really, that should take 5 minutes to deal with. And I said, let's pack, if you go to page 366, again, let me just make sure that yes. So it's 366 of the Maughan file. Just for the sake of convenience, so that the court doesn't have to, that's the place which I will use when I refer to the section. Remember, I said that the starting point on the merits should be the section that brought us here. And it's a very simple law, really, honestly. It's very, very simple. Forget about the purpose thereof now, and the 15 years and what have you. But it's an elementary piece of legislation. It doesn't need any magical interpretation. It says, very, very simply, no person shall, without the permission of the National Director or a person authorized in writing by the NDPP, disclose to any other person. Please underline that. There's no qualification. No person shall disclose to any other person. So unless if you are not a person, then you are not hit by this. The legislature doesn't do things for fun. When it gives such a wide definition, it is deliberate. If it wanted to say no person except a journalist, or no person except this and the other, it would have said so. And the exceptions are at the bottom of the thing. But it says no person shall, without the permission, disclose to any other person. Here's another thing. Any information. And this is where the problem is. Because we are told here about confidentiality and this and that and the publication in News 24 and what have you. But this law is very simple. It doesn't say you may not disclose any confidential information. It says any information. And then it says at B, you may also not disclose the contents of any document or any other item in the possession of the prosecuting authority. What is so difficult about that? Any record rather contents of any document, I'm jumping the book, or any other item in the possession of the prosecuting authority. Any document. Whether it's private or confidential or whatever, doesn't matter. And here's the catch, the point that we make in our heads. The obfuscation that you get in this case, and if you can overcome this, the case will become much easier, is that deliberately there is a conflation of terms. three in particular, and I'll say that in relation to the Karyn Maughan application. It's deliberate. I have no doubt about it. I've looked at the papers carefully. They deliberately conflate publication, confidentiality, and disclosure. Publication, confidentiality, and disclosure. And those three things must be dealt with separately. The statute only prohibits disclosure. It doesn't say anything. Whether I give it to Mr. Masuku, I disclose it to Mr. Masuku, and he takes it and puts it in his wardrobe, that information, and never does anything with it, I must go to jail for 15 years if I'm the prosecutor. The fact that what I give to my learned friend, Mr. Masuku, happens to be confidential medical information is just aggravation. It makes it worse. It might feature when we're talking about sentence at the end. It might feature that not only did I give him information, but I actually gave him, or rather, I gave him somebody else's private medical information. But it has absolutely nothing to do with the statute. Similarly, the fact that I give this document, I can give it to three people. One is an engineer, the other one is a doctor, the other one is a journalist. I'm still foul of this section. The fact that the one who's a journalist then goes on to publish it in whatever publication doesn't make them guiltier than the engineer and the doctor who do not publish it or do not publicize it. The crime is completed in all three of those accused persons. And what they do with it might differ. This one might tell 100 people, the other one tell 1,000 people. Maybe the one who tells 1,000 people must spend more time in jail or whatever. But that's a question of sentence. It's not a question of conviction, of the conviction or the... So this red herring about journalists, this and whatever, has got nothing to do. If Ms. Maughan, to make it this clearer, if it's not as clear, if she had been, the information had been leaked to her, but in her good judgment, she forgot, well, in her good judgment, she didn't publish it, but let's make it even worse. She just put it in her, somewhere next to her computer and forgot about it, and never wrote a story. The crime would still be complete because it's the disclosure of the information. And that goes to the unavoidable issue of the purpose of the statute. That statute was enacted to ensure that our prosecuting authorities are independent, fair, pure, non-partisan, and do their job professionally. That's all. That's all that differentiates me from Mr. Downer and Mr. Breitenbach and all these people. If I disclose information that I got from former President Zuma to my friends, nothing will happen to me. I'll just be reckless. But if I'm a prosecutor, I must go to jail for 15 years. The same me. It's still me. But simply because now I'm acting for a private citizen, I can I can go and talk about it in the shebeen. But if I'm a prosecutor, I may not breathe a word about it. The worst thing that can happen is that President Zuma, when he hears that I was talking about his matters in the shebeen, he might just decide to get another advocate who doesn't talk too much in the shebeen. That's all. That's the worst thing that will happen. But he can't take me to jail. But if I'm a prosecutor, I must go to jail. That, with the greatest respect, my ladies and my lord, is what we are here about. Nothing else. Forget about all these flowery things. Did Mr. Downer or Mr. Breitenbach or whoever it is in the NPA who was engaged, let's go to the statute, without the permission of the national director or a person authorized in writing by the national director, disclose to any other person, Ms. Maughan, any information which came to his or her knowledge in the performance of his or her functions in terms of this act, or the contents of any document or any other item in the possession of the prosecuting authority, yes or no? If he didn't, we'll apologize. If he did, he must be prosecuted and imprisoned. Finish and clear. Was it what Mr. Downer or Mr. Breitenbach disclosed to Ms. Maughan? Did it amount to information and or a document? The answer is yes on both. In fact, they are guilty of both 416A and 416B. Yes. It does. I'll come to that. Yes, my lady. It does. It does. That is the so-called sanctioning point. I'll come to it. That's one of the 4 points that... let me put it this way. Maybe let me address it now, my lady, so that I don't forget to come back to it. Firstly, the answer is that from the point of view of the public, the citizenry, it makes no difference because it's either one, there's one accused or two accused, let's say. But that somebody, nameless, don't even call them give them a name yet, that somebody acting for the NPA disclosed information to any other person means that the crime has been completed. Then we must then say, who is that somebody? Now, my learned friend, Mr. Badlander Sr., says that, well, Mr. Breitenbach is here. He says, I did it. Well, apart from putting Mr. Breitenbach under the bus, that statement does not assist Mr. Downer for the following reason. I don't know if I even have to make this submission. I can't go and rob a bank with somebody else or with 4 other people. And then when they catch me, I say, no, I was not the only one. They say, oh, why didn't you tell us, Mr. Mpofu? Please go home. I'm coming to that. I'm coming to that. Please be patient, my lady. Let's first accept the first proposition that I cannot do that. I can't say I was not the only one who robbed the bank. Full stop. Put that aside. Neither can I say, again, it's criminal law 101. Every book in criminal law has a chapter called participation in crime. And that chapter deals with the following 3 or 4 things, among other things. It deals with what we know as common purpose, which is the point you are alluding to, my lady. In other words, where you may not have been the only one, but were you part of did you participate in the crime? That's the first issue. Let's put that aside as well. It also deals with something called accomplices. That chapter in every criminal law book. And that again means you can be an accomplice even if you are not the one who pulled the trigger, right? Or who took the money from the vault. And lastly, it deals with something called accessories after the fact. Which means you may not have been there, that's your point. You may not have been there when the bank robbery was done, but if I come to you even 6 months later, and I say, hey, you know what? Wink, wink, I'm the one who robbed that bank. Can you hide this money? And you do that, then you are an accessory after the fact. So the presence or absence is completely irrelevant for accessories. But just to allay again Mr. Badlander Senior's fears, because he addressed this court about accessory after the fact. I'm not sure which one. I think it was Mr. Badlander Senior. We do not say that Mr. Downer was an accessory after the fact, because we don't have to. He may or may not be. But an accessory after the fact, that is covered in terms of Section 257 of the Criminal Procedure Act. An accessory after the fact is not something you necessarily have to plead in the substantial statement of fact, because it's something called a competent verdict. Another chapter, this time in a class of criminal procedure. So Section 257 and 258 actually falls under the chapter called competent verdicts. The big chapter, the big heading, sorry. Can't get my CPA. Oops. But anyway, the court knows this. Even if he was an accessory after the fact, he would have been covered by that section. What we have said in no uncertain terms is that Mr. Downer is an accomplice. We say he's either a perpetrator, again that goes back to that chapter of ours, a perpetrator, co-perpetrator, or an accomplice. It doesn't matter for the current purposes which he is. Why? Because, and that goes to the heart of your question, Justice Masipa, because we allege, right? Allege. Are we going to prove it in the criminal court? I don't know. But we allege that he performed an act of association, an act of sanctioning. In fact, I'm wrong, sorry. He, Mr. Downer, alleges, not us. He says, Mr. Breitenbach gave the document on the 9th at 16 something or whatever. Then he says, later that day, Mr. Breitenbach told me, Mr. Downer, that he has done so. And I then said, oh, well, no, we can come back to her tomorrow. It's fine. That's Mr. Downer, that's a confession in simple English. He says, when he had a duty, and we all know, at least as lawyers, that a crime like that, which is committed by omission, arises when there's a duty to act. So what was the duty of Mr. Downer when he was told by Mr. Breitenbach that he has just broken the law? His duty was to say, what? Did you really do that? And go to the authorities. Those authorities are to be found in the NPA or in the police or wherever he had to go. And Justice, I'll refer to, I'm sorry, there's I think it's the Downer file, page 123. So it's not me who's inventing this. It's the law. Mr. Downer attaches to his papers the policy, what he calls, it's BD10. BD standing for Billy Downer. Annexure BD10. He has put a explanatory note to the directives around the performance of work by prosecutors. And he says that document says the following, among other things. prosecutors should refrain from making inappropriate media statements, public communications, or comments. And it says the deputy directors and senior public prosecutors may act as spokespersons for the NPA on matters pertaining to the prosecution policy or any criminal prosecution. And then if any other member of the NPA is required to make a statement and so on to the media, comment in public or deliver a public address, the authorization of the DPP must be obtained. And here's the key. It says the purpose of responding to media or public inquiries, assuming all these authorizations have now been obtained, is to assist the public in understanding the nature and course of criminal proceedings and not to prejudice the parties before the court who cannot defend themselves against public comment. That means not to prejudice persons like former President Zuma. That's their own policy. He broke it. But again, if you don't believe me, our NPA Act expressly encapsulates, I think is the word, or receives the United Nations guidelines on prosecutions. It's part of our policy. It's actually even referred in the policy. And this is what it says. And again, Mr. Downer has kindly put it at BD 11, paragraph at page 125 of the Downer. And this is what must have informed Section 41.6. The United Nations concerned about the same things that concern former President Zuma and should concern every citizen of this country about prosecutorial conduct, says at paragraph 12, the role of prosecutors in criminal proceedings. Paragraph 12, prosecutors shall, in accordance with the law, perform their duties fairly, consistently, and expeditiously, and respect and protect human dignity and uphold human rights. Let's just pause there. They must respect human dignity. And if the way to respect human dignity is to give away people's private medical information, which they may, for good or bad reasons, have kept away from their family or their friends or whatever. We all know that. I'm sure all of us have a relative somewhere who was told, you have 2 weeks to live or whatever. And they decide, no, I'm not going to put my family through that. I'll keep that to myself or whatever. And if I went and then said, no, I'm just going to go around and telling everyone who cares that so-and-so has 2 weeks to live, and we say I did not affect their dignity, then we live in another world. And it says they must also uphold human rights, thus contributing to ensuring that due process and the smooth functioning of the criminal justice system. And then at 13 it says, in performance of their duties, prosecutors shall carry out their functions impartially and avoid all political, social, religious, racist, especially here, cultural, and sexual or any other kind of discrimination. In other words, all accused persons must be treated the same. There should be no special laws for Zuma and others for the favored people. And then it says they must keep matters, this is the heart now of the matter, at paragraph C, 13C, keep matters in their possession confidential. That is what informed our section 41.6. Unless the performance of the duty or needs of justice require otherwise. So again, it's that situation where unless immediately throws the onus on them, they must tell us why it was different here. Consider the views and concerns of victims when their personal interests are affected. Okay, then go to the bottom of that page, observance of the guidelines. 23. Prosecutors shall respect and present guidelines, and respect the present guidelines. They shall also, to the best of their capability, prevent or actively oppose any violation thereof, unlike our Mr. Downer. And number 24, prosecutors who have reason to believe that a violation of the present guidelines, that's your point, Justice Masipa, about whether you are present or you are just told by someone else after they have broken the law. It says, prosecutors who have reason to believe that a violation of the present guidelines has occurred or is about to occur shall report the matter to the superior authorities and, when necessary, to other appropriate authorities or organs of state. There are missing words there. You can just write them down. It's just 3 words. In that, it should say authorities and organs vested with reviewing or remedial power. So the duty is that one person authorized by the NPA can go to another and say, I've just given away information, and the other one says, oh, well, how do we assist? Instead of saying, what are you saying? I'm going to report you to the authorities in line with my duties that arise from the UN guidelines. That is what we have here. It is nothing. Sorry, I'm sorry. Sorry, madam. Yeah. Mm-hmm. 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 Mm. Yes. No. No, my lady, that is just incorrect, factually. We do see Mr. Breitenbach appearing. If you go to page 55 of the Downer file, in fact, before you do that, you can just put a finger there. And by the way, in the statement of fact, we refer to the UN guidelines at paragraph 6 at page 45, just in passing. But apropos what you are raising, Mr. Breitenbach, his first name is Andrew. And so if you go to paragraph 48, you see, I'm sorry, ma'am. 48 of the Downer file. No, page 48, paragraph 13. That's the so-called summary of facts. Your ladyship said we don't see him appearing in the summary of facts. It's called the summary of substantial facts in terms of section 144.3a of the Act 51 of 1977. I don't know if the pages are did you find it, my lady? Yes. Oh, thank you. Right. So Mr. Breitenbach is referred to at paragraph 13, and then he is also referred to, sorry. Ah. Yes. 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 No, my lady, let's walk slowly. So the first thing is that he's referred to. We agree there. Okay, good. Now, the next question is he referred to, in what capacity is he referred to? Okay. He's referred to in 2 separate capacities. One, as a perpetrator, co-perpetrator, or accomplice. And that's one. When I say 2, I mean, it appears in the very same document. Let's go to paragraph sorry. Where were we? We're in 14. Sorry, I've got the summary of facts. No, let's go to the. Let's go back to the complaint, the police complaint, which really is where this whole thing started. That was on the 21st of October. I've got the summary of facts. Now I'm coming there. I want to asking about the summary of facts. My lady, let me just say this. I'll find you the references because I'm chasing time. The answer to that question is yes and yes and yes. We say in our affidavit that in the police complaint, remember, there's a reason why Section 7 says when a DPP issues a nolle prosequi, he or she must certify that they've read the police statement and the complaint. Because otherwise, how do you do that? And I'll no, not in that, in the police statement. On the 21st of October. The reason is simply this, my lady. When you issue that nolle prosequi, you are doing so in relation to those who are mentioned and sometimes those who are not even mentioned. Anyway, we'll find it. It's the complaint statement. So he's referred there many times. He's also referred in this document I was reading to you now, the indictment, as a witness of Maughan. Yes. It appears in many places, but thank you, my lord. That's one of them. 333. Yeah, that's more rememberable. That's 33 of the Maughan, or 91 of 91 of Downer. Let's start with the one that is kind of fun. Okay, you'll see at page 338, about 9 and 10 August, Advocate W.J. Downer authorized or sanctioned the disclosure by Advocate A. Breitenbach, SC, that's the same person, of a confidential medical person to one newspaper journalist, Ms. Karyn Maughan. That's the first time he's mentioned. Then to assist your ladyship about whether he's an accomplice or whatever, we say at paragraph 14, as can be observed from the annexures, the most prominent feature of this case is that the complaints are based on conduct which has already been admitted by the suspects, in plural, okay, under oath. 14, madam. That's a 339, sorry, yeah. Okay, so the reason why we use the word suspects there in plural is because there are many people. And then it says at 16, this criminal complaint is completely separate cause of action which would bring the suspect to account for their own criminal conduct, irrespective of the outcome of the Section 106, which you will remember was still pending. No. The first question was, is Mr. Breitenbach mentioned? We've gone past that, yes. The second question was, how is he mentioned? Is he just mentioned, just for fun in passing, or as a criminal? Yes. So I'm saying yes. And for that, you must also look at paragraph 18, which says that the purpose of bringing the information contained in this affidavit to the attention of the police is to initiate a process which must necessarily lead to the prosecution of the suspects, failing which a certificate to the contrary must be duly issued by the NDPP, who is incidentally the person ultimately responsible for the deployment of the suspects. And then it says the criminal violations set out attached documents should serve as a useful basis for determining the scope of criminal investigations that the SAPS may conduct in this complaint and the inclusion of further suspects and accomplices. So there is no one reading this who would not understand that here the complaint first and foremost foreshadowed many suspects, and that the people who are named there, who include Mr. Breitenbach, by the way, are those people. But let me make your life easier, my lady. Like all prosecutors, public or private, it can never be an answer that if you want to prosecute, if there are two people who have committed a crime, myself and my learned friend, Mr. Buthelezi, and I, as the prosecutor, decides that Mr. Buthelezi will be a witness and I'll be an accused, then you say, where's Mr. Buthelezi? Why did you only prosecute Mr. Mpofu? The fact that Mr. Breitenbach, apart from everything I've said now, that he appears and is identified as a suspect, just like Ms. Maughan is included or listed as a witness, and Ms. Maughan is listed as an accused, or Mr. Downer, quite frankly, is neither here nor there. So so that's the first point. The second point, and that goes now, I know this takes me where I was going to go later, but since we're here, let's kill that point. It goes to the complaint by Ms. Maughan that the Nole prosecutor doesn't refer to her. The same answer that I've just given you, my lady, pertains to that, because let's remember the facts. What are the facts? We must always be guided by the facts. The facts are as follows. Having said all these things and postulated various suspects and accomplices and what have you, we then said, as I read out the paragraph 18, please go and investigate and include, if you find other suspects that we don't even know, the police might have found that the prosecutor. All we're saying is that go and investigate and find whoever you find and charge them. Right? But at the very least, the ones that we have mentioned here, Ms. Maughan, Mr. Breitenbach, Mr. Ramaphosa, Mr. Lamola, I think Ms. Batoi were the people who were mentioned by name. So we're saying those people are mentioned by name. There's no debate about that. But there might be Mr. Smith and Ms. XYZ. Yeah. So here's the issue. The NDPP, fortunately, my lady, understood exactly that is what they were asked to do. Because you look at their decision, they say, she says, I've decided not to prosecute any person in relation to this crime. No, I'm not. Long before that. That was just when they were trying to play gymnastics, to save the day. My lady, if you go to, I think it's the Downer file, the record, 500 and, okay, now it's volume 6 of the Maughan file, I'm sorry. Go to page 574, 575. you'll realize that a whole year before they came up with this trickery that no, we did not want to include Ms. Maughan or Mr. Ramaphosa or what have you. Long before that, this is what they said. On the 5th of April, 2022, last year, Advocate Ramutha, who's the Deputy Director of Public Prosecutions in Durban, said, I decline to prosecute any person in connection with this matter. Any person. Right? Of course, later they tried to escape the words of their own. And that, by the way, what then happened, my lady, is, and I'll paraphrase this, is what is set out in the supplementary affidavit that we filed on the 15th of December last year. We then said to them, we are now, remember this is April, right? So in October, Ms. Maughan and her lawyers come up with a clever lawyer defense. They say, no, no, no. This Nole prosecutor of the 6th of June only mentions Mr. Downer. So we're going to raise this point before this court. My learned attorney, Mr. Ntanga, then writes a letter to the NDPP on the 30th of September, 2022. You'll find that at 5:28. A1. Mr. Ntanga says, please, we have, it's a paragraph 7 in the next 529, says, the purpose of this letter is to seek clarity from yourself, that's the NDPP and others, as to whether or not the decision dealing to prosecute, indeed, it should be like refusing to prosecute or something like that. Yeah. Indeed, also included Ms. Maughan, as we contend it does, upon a contextual and holistic and business-like interpretation of the certificate. Our view is fortified by the belief that in issuing the certificate, the NDPP had read the statements, the one that I just read to this court. And we therefore request you to kindly issue an amended or additional certificate which makes it clear that it refers to Ms. Maughan. Alternatively, accept this letter as an invitation to make a decision one way or the other on the prosecution of Ms. Maughan by the NPA. If you decline to prosecute, please urgently furnish us with the relevant certificate to that effect. Right? That's the 30th of June. On the 3rd of November, or rather on the 25th October, you'll find that at 5:40. The NDPP, because of their bias inherent in this matter, and which is probably understandable because these are their own employees and so on, come and give us the what you call the party line. So they say Ms. Maughan was not contemplated as a suspect, but rather only as a witness. You got that at 5:40. That was I'm now required to decide. If I'm now required to decide whether or not to prosecute her, I require a full investigation to be conducted before I make such a decision. Now, you know, this is when my learned attorney, Mr. Ntanga, then stopped being Mr. Nice Guy. On the 3rd of November, he writes the following letter. He says, be that as it may, he says, you didn't apologize, we gave you a deadline, you didn't meet it. Be that as it may, the purpose of this letter is to inform you that our client roundly rejects your decision to exclude Ms. Maughan from the ambit of the Nole Prosecutor Certificate as unreasonable, irrational, biased, and motivated by ulterior and improper motives. Your inherently biased attitude in this matter is understandably based on the fact that the prosecution involves Advocate Downer SC, who is your colleague and whom the NPA has repeatedly praised in public, in spite of and in opposition to our client's exercise of his constitutionally protected rights to institute a private prosecution. This attitude previously was exemplified by your transparent delaying tactics in producing the nolle prosecute certificate on 6 June, despite having made your decision not to prosecute on 7th April. Furthermore, the NPA has a direct interest in the prosecution in that it is funding the defense of accused number 1. That's the whole issue about the state attorney. Your automatic bias must also be viewed against the issue of financial interest in addition to the relationship-based interest. It is illogical to claim that Ms. Maughan was, quote, contemplated as a witness when the affidavit, which you are deemed to have read, clearly identifies her as an accomplice and a suspect. That is what was clearly expressed by the complainant, to use your phrase. And then we go on about, we quote the paragraphs that I quoted to you earlier, my lady, at 5.1. Paragraph 11 of the complaint statement, paragraph 7, paragraph 15, paragraph 18, paragraph 19, and at 5.6 we, and then we quote the certificate itself. It says, I, Elaine Zungu, that's the DPP, duly appointed as DPP, certify that I have seen all the statements and affidavits on which the charge is particularized below is based, and I decline to prosecute at the instance of the state. Then we quote Ndumeni, which I won't go into. That's the one about context and purpose. And then we say, in any event, you have sufficient time to make a decision. We say, this is paragraph 7. Given all these objective facts and in the blatantly irrational of your decision, it is incumbent upon you to assist in avoiding unnecessary and protracted litigation in this matter by forthwith, 1, reversing the aforesaid decision, 2, making a decision whether or not to prosecute Ms. Maughan, 3, issuing the requisite amended or separate nolle prosecute certificate by the deadline set out below. And then we're instructed to demand, as we hereby do, that you furnish us with your urgent response by no later than Friday, 11th November, failing which urgent application and to review your decision will be launched without any further notice, and which punitive cost a bonus will be sought personally against you and or the NDPP on the grounds of conduct which is patently arrestable in bad faith and tainted by bias. So Mr. Zuma then says, well, if you're not going to give me this, I'm going to go to court. That, my lady, is what brought, then they capitulated, to just put it bluntly. At page 548, after this letter, then on the 21st of November, that's how we got if we hadn't threatened the legal action, we would have been left with that nonsense of saying that she was not contemplated as a. So even here, I think they found it very difficult, shame. So this is what they said. The certificate is now issued 21st November, a few days later. I, Elaine Zungu, duly appointed Director of Public Prosecution in KwaZulu-Natal, hereby certify that I have seen all the statements and affidavits on which, I'm at 548, yeah, on which the charge particularized below is based, and that I decline to prosecute any person in connection with this matter at the instance of the state, which is exactly what we have been saying to them, that even though the 6 June certificate is written Billy Downer, if you interpret it in the context of the police statement and what have you, and the suspects that are named there, then obviously it embraces them. So eventually they saw the light, or apparently they took legal advice somewhere, and then they issued this certificate. So that was the end of that little trick. And so that's what we call clarificatory certificate, and it must not be elevated to anything more than that. And there's another deception, to try and portray the second certificate as if it's a standalone certificate. No. We demanded of it as a clarificatory certificate, but our insistence has always been that the 6 June certificate, properly interpreted, embraces Ms. Maughan, Mr. Breitenbach, whoever, Mr. Ramaphosa, Mr. Lamola, Ms. Batoyi, whoever is mentioned in that statement. So that's how. So to come here now, after all this, now in 2023, in March, and still assert my learned friends, Mr. Stephen Badlander, to come here and say the nolle prosequi does not include Ms. Maughan. It's just really, really, really just, after what I've just described to you, how the NPA itself, after being compelled to do so, clarified and widened the certificate to include any person. And if that is not enough, by the way, the NPA, in another act of irregularity, and that will be referred to in the Ramaphosa case. This time they were trying to save someone else. So they said, no, if it wasn't so tragic, it would have been laughable. On the 24th or 21st of December, just before Christmas, they issued a statement and said, no, this is now head office. We want to tell you, world, that Mr. Ramaphosa is not included in the nolle prosequi, because that nolle prosequi only applies to the persons who are mentioned in the police complaint. So obviously, this was someone in head office, who had not read the police complaint. So we told them, yes, but Mr. Ramaphosa is mentioned in the police complaint. And that was the end of that. We've never heard from them since then. And but there's also, it's called, for the purposes of this particular matter, it's common cause that Ms. Maughan is mentioned in the statement as well. So even on that version, which was for ulterior purposes, where they say it's only the people who are mentioned, both Ms. Maughan and at least Ms. Maughan is in. So I don't know why we're here debating this simple and obvious fact. But in any event, my lady, I think it was my learned friend, Mr. Badlander, who said he's never heard of this thing about receiving something being a crime. Maybe it was Mr. Stephen Badlander. Well, if they haven't heard of it, that's fine. That's tough luck, because we have some of our crimes involve that. There's the colloquial saying that says, where there's a corrupter, there's a corruptee. There's even a crime of receiving stolen property, knowing it to be stolen. So all we're saying in this context is that the discloser, to steal that Anglicism, the discloser is as guilty as the disclosee. In other words, if I disclose the information obtained from, I've read the statute, I'm not going to read it again, and you receive it, then at best for you, an accomplice. But it doesn't matter, because those things will be argued in the criminal case. For now, the question is whether you are criminally liable, whether it's as an accomplice or an accessor after the fact or what have you, is not for now. So is okay. Well, thank you. As court pleases.
He was subjected to it, but we choose to consider what he chose.
He chose
The
that.
choice. Because
And-
the law is there that says you can stop.
That's right.
So it was his own choice.
Quite right. I mean, the law does seem to be that you can raise abuse of process through one of six and eight. That's what-
Yes, I think
There are
he
cases
did
that
say
say that. It sounds wrong,
sounds very wrong.
because the point of a plea is you plead to the charge. You're not saying the whole case is wrong.
So I think they can drag the investigation
Yeah.
to preliminary study if the law start.
Yeah.
Why should you say
Yeah, absolutely. I think the answer is that you've got a choice. You've got an election title,
yes?
then you've got to raise it as a special thing. Well, the longer they take, the less we have to listen to Dali.
Is the our section 7(1)(a) not
Arguably. Yeah. Arguably. I agree.
except that the answer is that we could raise it, we are raising
We're raising it here. And this is the
There
way
isn't any
it's been raised in all the cases for 70 years.
yes. And I suppose the point is that the fact that the knowledge gives you an opportunity to sum up everyone needs to be decided.
Yeah,
You wait.
it's very important.
Because the powers that are given by the protocol
It can't possibly be that anyone who's remotely mentioned on that basis, you could have prosecuted, you can prosecute, you can do all sorts of things. I've got a sucking sweet at you. But never mind, don't worry. You would rather do this.
Send WhatsApps to Lawson.
Yes, something important.
No, I don't, I'm afraid.
Don't worry, forget it.
Sharp. Got any sweets? My father's looking for a second sweet. Trying to oblige you, your dutiful son. No, it's just if you happen to have one.
Only if you have one.
I've got a slightly grimy gummy bear. I wouldn't take it.
No,
Yeah.
thank you for that
No.
advice.
It's got sort of sand.
Where did you find this?
In my bag somewhere. It must have been put there by one of the children.
Thank you for that good advice.
My boss said you are clearly a person of impeccable
I
judgment.
consider this high quality medical advice. All I want to know is if you send me a bill for the advice, can I get it back on medical aid?
I actually think we started at 2:15 yesterday as well.
He's usually very punctual.
I wasn't convinced by this. But Karyn sends
Those are
these.
fatal. Please take those away from me.
No, take them. They'll just melt. Thank
They'll
you.
melt and I love them. But
He'll eat them all, Sean,
I'll
but
eat
thanks
them
for
all.
your efforts.
Nick brought me a whole box of those the other day.
If that's a weakness you share with my wife, she can't buy
She
them
wasn't-
anymore.
I can't buy them either.
She,
But Nick knows.
she can eat a whole box.
Yeah. I could easily do that. He walked in with a whole bloody box of these things. Smiling happily. He was making his dad happy.
Got lost.
as it were, wrap up the point that I was busy with. As I said, the arguments just took us there, fortunately, but just so that I don't go back to it, which was the issue, one of the what I call the peculiar points, which are specifically only raised by the applicant, Ms. Maughan. And that was the issue of the null prosecution. In our special submission, the response that I gave to one of the justices about that covers the why that point is not a good point, and why the null prosecutor clearly, at least once it was clarified at our insistence by the NPA, that it is wider than merely referring to Mr. Downer, which in any event was always the case. Then that point, with respect, should have just been abandoned. But it's being pursued nevertheless. And this is despite the fact that the NPA received legal advice. And this is really, this also goes to the question of costs, the kind of cost order that we should be entitled to here, which should be punitive in nature. Because it's one thing, it's understandable, with respect, my ladies and my lord, that Ms. Maughan, and now let's not even talk about her lawyers, let's just say as a lay person who's not a lawyer, it's understandable that she could say, oh, here's this null prosecution, but where's my name in it? I mean, the lawyers should have explained it to her, obviously, but I'm putting the lawyers aside. But once it has been explained that, no, a null prosecution is not read like that. The reason why Section 7 insists that the DPP consent must specifically say, in fact, whether she specifically says it or not, it is deemed that she has read the complaint, the complaint, police complaint, the affidavit, and all that. Why did the law say that in Section 7(1)? Because it did not want these kinds of situations where an accused person comes back and says, no, my name is not there. And we say, no, it was in the statement. And then the DPP says, oh, I didn't read the statement. By the mere act of releasing a null prosecution, she is representing that she has read the statements, and she knows that there are many suspects. So all I'm saying is that once all that was clarified as between the attorneys and the new certificate, the clarificatory certificate was issued, that point should have been abandoned at that point. So from that point onwards, which is the 21st of November, the costs of pursuing that particular point should be visited on Ms. Maughan on a punitive scale, and even her attorneys, because they themselves should also have said, okay, well, this point maybe was a good try, but now it has expired. And that goes to something very significant. And it is that it's another point which I think we can get rid of very literally in 5 minutes. Another non-point. You'll remember that both applicants raised the Section 7(1) point of saying that former President Zuma has no peculiar interest or injury suffered as a result of the alleged crime. I mean, really? Can you say that? Remember, for the purposes of this point, you have to assume that everything is true. You have to assume that his medical information, as a person, forget that he's a former president and all that, and that because of that, in any event, his information is protected by secrecy acts and all sorts of things. Forget that. assume this was just Mr. Themba Mkhize down the road. Can anyone really with a straight face say that the dissemination of the private medical information of that person is nothing? What are they talking about? They are not suffering any injury. When that person says, I specifically withheld some of this information, even from my children, I specifically made sure that nobody knew, at least I didn't, and I'm his lawyer. But I didn't know that he was suffering from a life-threatening disease. I didn't. Maybe other people did. I didn't know that there had been an 18 months wait for a particular procedure. I didn't know that. And that is the information that was leaked. And we were told with a straight face that what is it going on about? He hasn't suffered any injury. Quite apart from the fact that that issue in any event should be, it's a matter of title to prosecute. That's vintage Section 106 issue, if Justice Kuhn is to be believed. Mr. Badlander, to the junior, correctly called it a jurisdictional prerequisite as envisaged in Section 7.1. But its absence is a matter of title to prosecute. Because what in simple English, not in simple English, in legalese, what you are saying when you are saying a person doesn't have peculiar interest, you are simply saying they don't have a title to prosecute in terms of Section 7.1. So that issue should not even be raised there, it should be raised in the criminal court. But for the purposes of this argument, let's assume it can be raised here. It has no merit. It is insulting, actually, for anyone to even utter that. It's the height of arrogance and bigotry to say he must just deal with it, you know, if his information is being bandied about all over or has been released by the prosecutors. So I don't think we need to spend time on that for the two reasons: that A, it should be raised later in the section under Section 106, and B, even if it is to be raised here, it is completely meritless. Even Justice Kuhn could not get himself to saying that this doesn't matter. He said it to the extent that it is injurious, it did not affect the free trial rights, which is something he was dealing with. But at least there was a half acknowledgement that this of something that really any human being, one doesn't have to be a lawyer to understand that the dissemination of your medical information is something that's dear to all of us. I wouldn't like, even if I have a headache, I don't want the whole world to know about it necessarily, let alone a life-threatening disease. So that point with respect, we shouldn't waste time on it. So let's get to the issues that they do raise. We've spoken about the Ms. Maughan's being clearly covered by the nolle prosequi. We've spoken about the Section 7.1. But before I go to the next topic, if I may, if the court allows me, just to round off a point that was raised by Justice Masipa around about this other red herring of, like, was it this one, was it that one, or was it both? Was it Downer, was it Breitenbach, was it... Our case is very clear that by his failure to do the things that I've said should be done in terms of the UN guidelines and other instruments. And in that respect, I've taken the liberty, I beg leave to hand up copies of the Government Gazette, this is the same document that Mr. Downer was referring to, and I've said that it's some of it was not complete, but that's the UN document I referred to. But this is where it is made clear that it is part of our law, or it's subsumed. I remember struggling for the correct word here. So this is Government Gazette of 29 December 2010, Department of Justice, and Code of Conduct under Section 22(6) of the NPA Act. Signed by the then NDPP, Mr. Menzi, Advocate Menzi Simelane. On the front page, it says, I, Menzi Simelane, National Director Prosecutor, acting under Section 22(6), and so on and so on. But I want to draw the attention of the court to this next page, where it says, in framing this code, the minister, you remember in 22(6)A, it empowers the minister to do this kind of thing, regulations and other things. In framing this code, the minister, deputy national directors of public prosecution and directors of public prosecutions were consulted as prescribed by the Act. Due account was taken earlier to the values and principles enshrined in the Constitution of the Republic, the aims to be achieved as set out in the Act, the United Nations guidelines on the role of prosecutor, as well as standards of professional responsibility and so on. So South Africa is not just a signatory to that UN document, but it has been specifically received. So so the duty to act. So the failure of Mr. Downer to act is a crime because he had a duty to act under these guidelines, among other things. But even just under in common sense. Now, the issue, Justice Masipa, is that we allege that, therefore, Justice Downer, Mr. Downer or Advocate Downer sanctioned, by omission, sanctioned or authorized, and in fact he did more than that. It could have been that he just kept quiet and didn't go to the police or whatever, but he actively participated. He's the one, after all, on the 10th, who then told Mr. Breitenbach that I've now signed the document, and so on. So again, in the criminal trial, of course, he's going to testify. He can say, oh no, actually, Mr. Breitenbach, I don't know, told me that he had the authority of the NDPP. I mean, I don't know. So, but there is no, as we are sitting here now, there's nothing that absolves him from the responsibility he had to act in terms of the guidelines and either report or act on. As I say, when they're all, fortunately, all of them are witnesses. Mr. Breitenbach is a witness, Mr. Downer is a witness. And that's what happens in every criminal trial. We all think it looks like this, somebody fired a shot, therefore they are guilty of murder. And when they go to court, they say, no, it was self-defense, whatever. That's not for this court. That's for the other court. The simple question before this court is prima facie on what we have here. Is there this lack of authorization? Is there this condonation, sanctioning, authorization, whatever you call it, by the mere fact of non-action? If the answer is yes, that's it for prosecution. Whether he'll be found guilty or released in terms of Section 174 at the trial is of no concern to this court. So I hope that is behind us. What is it that we are really accusing Mr. Downer of having done or failed to do? Yes. Now, what makes it even worse in this particular case is that there is no world in which Mr. Breitenbach could have been authorized to do what he did. Even the lame excuse made by Mr. Downer that somehow deputy directors can do certain things under certain conditions, interact with the media, what have you, which doesn't apply here really. He should have known, or ought to have known, that that can never apply to Mr. Breitenbach, because Mr. Breitenbach is neither an NDPP or a deputy public protector. So he knew. That's called an act of association. That's what happens when you go in a bank robbery and your only role is just to drive the getaway car. You don't even get inside the bank. You just sit outside and drive the getaway car. You are charged together with all those who participated in the crime. You can't say, no, it's this one who took the money, it's this one who pointed the gun, it's this one who gave the teller the note. I mean, I was just waiting outside in the getaway car. No, it doesn't work like that. Which takes us to, with the greatest respect, my lord and my ladies, again, I've said the earlier point about conflating confidentiality, publication, and disclosure is a big point. But they don't come bigger than this point. The other wool that is pulled over your eyes, or at least the attempt to pull the wool over the eyes of this court, which is disgraceful, by the way, just so that I get it out of my chest, is the attempt to say that, to tell the lie that when Mr. Downer or Mr. Breitenbach or anyone else in the NPA that we don't know about conspired to leak this document, at that point the document was a public document, and Sanral, blah, 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 you get told Sanral, the Sanral case applies, and so on. It's a blue lie. Everybody knows that is not true. How do I do that? Because the documents themselves, again, I'm not relying on anything we say, I'm relying on what they say. You will see that the first thing they do, every time the story is told, even yesterday or the other day, Mr. Baler's friend, Mr. Badlander, said, let's deal with the chronology. And then he says the application was sent to Justice Kuhn, and at 1643, Ms. Maughan requested Mr. Breitenbach to give a document. Then he says 3 minutes later, Mr. Downer sent it at 1646.
Mr. Breitenbach.
I'm sorry, Mr. Breitenbach, thanks, yes. And so on and so on. It was already a court document, says Mr. Badlander. It's not true. The document on the version of everyone. The first lie is this, it's another lie by omission. Because you'll see even in the affidavit, it starts like that. No, at such and such a time, Mr. Breitenbach, depending on who you are listening to, Mr. Breitenbach, Ms. Maughan requested the document from Mr. Breitenbach, and then Mr. Breitenbach sent it to her. Firstly, this conversation, which led to the leak of this document, was not initiated by Ms. Maughan. It's a lie. The conversation was initiated by Mr. Breitenbach. We only discover that when he makes the police statement. All along we were told Ms. Maughan made an inquiry, a media inquiry, routine. All journalists make inquiries from all of us. No. Mr. Breitenbach, out of the blue, called Miss Maughan. Miss Maughan was minding her own business somewhere in Pietermaritzburg because he wanted to leak this document. He called her and said, the WhatsApp exchange. Sorry, when I say called, it includes the WhatsApp exchange. It's actually better because we may not know what was said in the on talking. So the WhatsApp exchange actually assists us. I'll take you to it now, but it goes something like this. Yeah, are you already in Maritzburg? Because it looks like there's going to be a postponement or whatever. The other one says, I'm here in Maritzburg. The next 2 or 3 minutes, he sends the letter which was sent to Justice Kuhn. The next 3 minutes, he sends the unsigned affidavit. Now, really, and they say, what are we talking about when we say it was leaking? In which world does a prosecutor, national prosecutor, phone a particular journalist, not the media, as they say somewhere, they say, no, then it was given to the media at 1640. No. It's given to a particular journalist for a particular purpose in a conversation initiated by the prosecutor. But here's the catch of all catches. Mr. Downer and Mr. Breitenbach tell us, and Ms. Maughan, tell us that there was an arrangement made among them that please do not write your story in this document until the document is filed tomorrow. I'll take you to the thing. So everyone knew that the document will only be filed tomorrow. It was Women's Day on the 9th of August, 2021, public holiday. And therefore they say it's going to be filed tomorrow, obviously, when the court opens. Now we are told stories. So on the 9th of August, it's known to everyone. In fact, again, one doesn't have to be a lawyer or a genius or anything to appreciate this point. Anybody will know it. You ask it in what we call a rhetorical question. If there was nothing wrong with publishing the document before it is filed, then why was that arrangement made? Why was it necessary to say to Ms. Maughan, don't publish until tomorrow or until the document is filed? It's because everybody, including Ms. Maughan, knew, that's what we call mens rea in criminal law. Everyone knew that it's not done. You can't publish this story until such time that the document is filed. So again, we have another confession, because that little arrangement on its own is a confession. Because nobody gives a document to a journalist and say, no, but don't print it until tomorrow because I must still file it. And then comes here in front of a court of law and say, no, the document was filed. If it was filed, then what was the problem? They know, and they know very well. They're just trying to fool this court and the public into I don't even know what to call it. It's worse than obfuscation. And that is where the rub is. Because, and remember, by the way, even if the document had been a so-called public document, that only goes to the issue of confidentiality and publication and so on, not the disclosure. The disclosure, we're way past that now. The crime has been completed of the disclosure. the Miss Maughan, therefore, whether you look at it as information, which is section 46, I'm sorry, yes, 46(1)(a), 41(6)(a), yes, thank you, 41(6)(a), or whether you look at it as the document, the hard document from Dr. Mdutjwa, which is 41(6)(b). It doesn't matter because they breached all those separate statutes. And the document that makes this very clear and obvious is the well, it's three documents. It's the affidavit of Mr. Downer to the police, the affidavit of Ms. Maughan to the police, and then the affidavit of Mr. Downer in the postponement application. I'll give the references now. But the court can, for now, just be assured that the version which is bandied about here is that, I think it's 270 of, sorry. The version is that Mr. So-called, sorry, Sandral, sorry, that the Sandral case applies because the document had been filed on the 9th, which on anybody's version. And let's put aside now that at 9 o'clock, 21:07, Mr. Tusini was the attorney, included the document. So when I was explaining this to my learned juniors, I said, for a minute, let's assume that Mr. Tusini's affidavit was sent at 12:01, just so that the dates can work here. But it doesn't matter which way you do it. You can either use that analogy, or you can say, let's look at everything that happened before 9 p.m. What happened before 9 p.m. is that the crime was completed because, to everybody's knowledge, the document had not been filed and should not have been used. Now, Mr. Downer, at least to his credit, attached the email which they sent to Ms. Griffin, that is the registrar of Justice Kuhn. And it says very openly that the document will be filed, quote unquote, tomorrow. And please, Ms. Maughan even sends a message to say it will only be their version if I publish now. So please tell me when Billy, quote unquote, Advocate Downer, has filed the document. So there can be no doubt in anybody's mind, any neutral person, that it's what we call in law, in criminal law, knowledge of unlawfulness, which is a form of mens rea. It's dolus directus. But if you want to be kind, it's dolus eventualis. But it doesn't matter, it's dolus anyway. But I say it's dolus directus because the evidence of the dolus directus is the arrangement. Had there been not that arrangement, it would have been open to the accused to say, oh, well, we made a mistake of law. We thought it had been filed, even though it was just an unsigned document, uncommissioned. So it was not only unfiled, it was uncommissioned as well. But what is worse, Justices, is that so-called affidavit was actually unnecessary. There's no, this was just a vehicle for the leaking of the medical document. When we get to the criminal case, we will bring evidence to show that, when we show the state of mind, we will show that this was an intended crime. Because Justice Kuhn, Justice Kuhn said this: I'm giving you a directive. The applicant, the accused, that is Mr. Zuma, must apply for a postponement and tomorrow, and he doesn't have to be there because he was in prison. He doesn't have to be there, and we made a concession. Before that, we were fighting because we wanted his rights to be present, which every accused person enjoys, to be respected. But we said, unlike all these insults about Stalingrad and what have you, we said, no, that's fine. He's in prison, there's COVID, we'll go on without him. In fact, when we argued in this room, the Section 106, 1H, he was not even here, because he, not even us, had made that concession to say it's fine, carry on with the matter, even if I'm not there. So there is that arrangement. Justice Kuhn then says we must apply. While we're busy applying, making the application, we must apply. We're the ones who want the postponement. They put an affidavit, a nameless affidavit. I don't know what it is called. Nobody asked them to put any affidavit. To do what? We must apply for a postponement. And then they must do an answering affidavit, and then we reply. That's how it happens in all courts all over South Africa. I've never heard of the respondent in the application for a postponement being the one who gives an affidavit first. It's not done. It was just a subterfuge to channel the crime. Anyway, they send that so-called affidavit, which is unsigned, uncommissioned, unsolicited. And they know that it is not, it is not a court document by any description. Now, a lot of heavy weather is made by them about the fact that Mr. Tusini, the attorney at that stage, sent the document the following in the evening. Well, again, that has got, firstly, let's agree that has nothing to do with the disclosure point. It might have something to do with the confidentiality point, which is, as I say, aggravation, a matter of sentence. Because I can understand at the end of the criminal case, if Mr. Downer says, okay, don't give me 15 years, give me 5 years. He might say, look, insofar as the document was wrongly disclosed, then in any event, later it was revealed. And therefore, I must not be treated like the worst kind of criminal who has... that's fine. We'll deal with that when it comes. But for now, when we are only talking about whether there's a prima facie case of liability, that fact is mightily irrelevant because it goes to aggravation or confidentiality or publication. I've already made the submissions that the publication was not necessary. She might even not have published it at all. Aha, let's go there. Judge Kuhn does not disagree with me. That is wrong. That's another subterfuge that is pulled over the eyes of the court. Go to paragraph 240 of Judge Kuhn's judgment. You'll find it at page 147, I think, of the Karyn Maughan. Sorry. Yes, it is the Karyn Maughan. I think it's 147, my lady. Yes. Page 147. It starts at, it's K149, sorry. Starts at, it's KM17. It's an annexure to the founding affidavit of Ms. Karyn Maughan. And you'll find what they say is that point, let's call it res judicata point. So they say, no, this was decided by Judge Kuhn, and not only that, it was decided against us. Well, let me tell you something. At least if Mr. Trengove was here, he would tell you what I said standing here. I said on the 22nd, I think it was the second day, on the 22nd of September, standing here, I said, my Lord, we want to bring to your attention this matter that there has been a crime that has been committed, and Mr. Zuma, my client, in absentia, intends to prosecute around it, because section 41(6) and 7 of the NPA Act makes it a crime. Justice Kuhn, who was a good and exemplary upholder of justice, at least in that respect, he says it here, and we appreciate that. Even where we differ with Justice Kuhn, where we appeal against him, we have never said that he did anything else than making an error, because we are all human. This is what Justice Kuhn says. He actually says the opposite of what you're saying, Malid. He says, I'm not deciding this point. 240, I said, which is at page 239. 240, the paragraph in the judgment. You'll see the previous paragraph, he quotes section 41(6) and 7, the one I said, no person may disclose, and so on and so on. Then he says at 240, as the complaint was only made in argument, and then in reply, an argument by me, which is what I've just told. And then in reply, dealt with by Mr. In reply, yeah. It's still by me. Mr. Downer did not have an opportunity to respond thereto. I accordingly did not have the benefit of the issue having been dealt with fully in argument. In those circumstances, I consider that it will be improper to consider the request for any such referral further in this judgment. Let me pause there. What we were asking for there was to say, please, Justice Kuhn, in your judgment, we know that this thing has just arisen now in reply, but in your judgment, please add an order that says this thing must be referred to the NPA for further investigation. And he says, no, I can't do that because Mr. Downer has not had a chance. Then he says, apart from the procedural difficulty, I have doubt, that's not making a decision, whether the wide terms of 41(6) are necessarily constitutional. So he raises a whole different point, which is not raised in this matter, about the constitutionality or otherwise of 41(6). Does not arise here. That's the point that Mr. Masuku was making about, and Mr. I don't know if Mr. Ngalona touched on it, about subsidiarity. That if one of these parties, and there are so many amici and all sorts of people here, If one of them had come and said, look, maybe this situation was never envisaged. This section is unconstitutional. It should have a clause that says no person except a journalist doing his or her job and may disclose to any other person. But when it says no person, it breaches the Constitution and so on and so on. So that's what Justice Kuhn was trying to say here. And I'm sure he was hoping that someone will raise the point. So it's even worse than Obita. He's just talking, but you'll see how he described it. In case it looks like I'm being unfair to him, you'll see how he described it himself. Then he says, what is prima facie view and so on. And then here's the other part. I would have thought, I mean, these are the kinds, he's just chatting. Yeah. I would have thought that Section 41.6 would not, would not, for example, prohibit a member of the NPA, listen to this, in response to inquiries from a journalist. See, because he had also been hoodwinked to think that there was an inquiry from a journalist. He didn't know that it was initiated by the NPA. Yeah. To confirm or deny that a particular suspect might not be formally indicted, in particular charges, or the assistance regarding a particular investigation in another jurisdiction was being pursued. Continues with this speculation. But here's the killer. But these are simply ruminations without the benefit of having heard considered argument. If it is believed that the provisions of Section 41.6 outlaws such conduct, then a formal charge in that regard can be pursued, where the proper application of Section 41.6 can be fully ventilated and its proper interpretation determined, according to Ndomeni and according to Section 39 of the Constitution. So to use this to say Justice Kuhn disagreed would really be to take it too far. But I don't blame your leadership. That's what is the finder that is being played here to make the court to believe, because that's one thing. The first thing Ms. Maughan and Mr. Downer say this. We don't know what this is going on with Mr. Zuma. Didn't you hear that Justice Kuhn disagreed with this? That's the extent of the so-called disagreement. Ruminations, chit-chat, speculation, maybe if it's unconstitutional and so on. Really. And again, to Justice Kuhn's eternal credit, well, maybe I should say Mr. Masuku's credit, because he drafted that part. The issue that I've been at pains to explain here, that the 41.6 matter is different from confidentiality, is clear from the judgment of Justice Kuhn. You can go to page 236. You see the heading there. It says Mr. Downer's alleged leaks to the media. So it deals with the issue of the leak, which is what 41.6 is about. Separately from the other heading, which you will find at, in fact, it's even intercepted by another point. But if you go to the issue of the confidentiality, it deals with unlawful attempted examination and so on. Sorry. Oh, yes. Page 241, paragraph 246, you'll see the heading there, the leaking of confidential medical information. So he makes it clear that these are two different grounds. There's the leaking, which is what brings us here. Then there's the issue of the medical information, which is a separate point, which has nothing to do with the crime, but is a, as I say, at best aggravation or a basis for the injury suffered. But I'm afraid I have to explain how we interpret laws in South Africa, which is contextually and in terms of the Constitution. So 41.6, not only do we have Ndomeni, Not only do we have, because this is a statutory crime, this book called the Constitution says that at section 39(2) of the Constitution, when interpreting any legislation, when developing the common law or customary law, every court, including this one and any other court, tribunal or forum, must promote the spirit, purport, and objectives of the Bill of Rights. And those spirit and purport is explained in 39(1) as promote the values that underlie an open and democratic society based on human dignity, including the dignity of former President Zuma, equality and freedom. So the court actually has no option in this. This court has to interpret 41(6) and infuse into it the values of our Constitution, which includes the protection of the human dignity of former President Zuma and not leaking of his documents. And the purposive interpretation, which I started with, says that the purpose of that section 41(6) is to ensure that it gives the harshest punishment to anybody in the MPA who is guilty of this, or anyone else who aids and abets the commission of that crime. But let me just move to something else, which is this. Assume everything I've said is wrong. Everything. What the other side does not respond to is the fact that we have another count. We have another crime. Mr. Downer has proven himself to be a serial leakist. He leaked the documents. He leaked them 14 years ago, or however, it doesn't matter how many years. He did the exact same thing, my lord and my ladies, in relation to a journalist in the Mail and Guardian called Mr. Sam Soul. So all that has happened now is just removed his Mr. Sam Soul with Ms. Karyn Maughan. The journalist that he used to leak, and this is a separate charge, is Mr. Sam Soul of the Mail and Guardian. And Mr. Downer, the same Mr. Downer, go to page 109. Sorry, I think that should be 109 of Downer. Where's that? Sorry, I'm sorry, my lord. Yes. 109 of Mr. Downer's bundle. This is the good thing about all these things is that Mr. Downer puts them himself in these papers. Mr. Downer, this is a conversation he had on the 5th of May, 2008, with Mr. Soul, a prosecutor in our democratic republic. Look at conversation 2, you'll find that at 110. I'll just read it for context. Hello, this is Mr. Downer. Soul. Billy, Sam, can you talk? Mr. Downer, hello, Sam. Yeah, sure. Soul, listen, we got pretty good information that the Germans are in the process of striking a deal with Tyson in Germany. Mr. Downer, right. Probably next week or within the next 2 weeks and so on. And then the next page is, we've written, Mr. Downer now, we've written to them and told them that we know this is going on. I was just gonna say you need to extradite. Thanks. We got that info from Richard Young as well. Now that is a crime. He says he's giving information that belongs to the national prosecution. And that's what info means, information. He says, we've written to them, that's number one. We've told them that we've got this is going on. I was just going to say you need to extradite. And then he said, thanks, we got that info from Richard Young as well. In other words, I'm confirming this info that you are those three aspects. Okay, so that's the first part. But it gets worse. Go to page 111. This is Mr. Downer. BAE new investigation has to be declared. New terms have to be assigned. In respect of the Germans, the terms of our 2002 declaration of investigation include the whole of it for them, not to be declared ongoing since 2001. And here's the catch. But you can't quote me to say that. This is the prosecutor innocently doing his job. If he's innocently doing his job, why is he saying in secret, but you can't quote me to say that? He's leaking. Says, no, I'm not going to quote you at all. There's the deal, done. Then he says, it goes on, say that ongoing investigation on SA side. Let me just quick. You know what's happening here? It's not just leaking. It's what we call in the media industry. I used to work in it. It's not just leaking, it's coaching. You leak information to the journalists and then you coach them how they must even report it. So he says, say that ongoing investigation on SA side. In other words, Germans may have dropped theirs, but we haven't dropped. You can refer to the terms in the 2000 investigation. Formal terms of reference include in there. I didn't know, listen, we must sit down. Quite a lot of stuff that I can share with you. Right? And then it gets worse. And then he says, this is more information at page 112. Incoming requests in terms of Section 7, all the DG is to do, if done in terms of Section 7, is to get the minister's consent, send to magistrate. All magistrate can do is to issue subpoenas. In terms of that whole process, the investigation has been carried in South Africa, is very limited. People have been called in front of a magistrate and have been asked questions. That subsidiary process of triggering South African investigation is done as an exchange of info between the investigation agencies. And then Sensol says something about incoming requests and so on. No. I'm reading this because in the indictment of these two accused persons, there is a count, I think it's count 3, which relates to this crime that I'm dealing with now. All right. Now, which, by the way, the NPA said we don't have to look into this. That's all you have. Then it's the NPA which employed him. Then on the 18th of June 2008, this is what it says. There has been, at the bottom, there has been a formal request for a joint investigation. Billy says, yeah, but just avoid the terms joint investigation because the minister hated it. That's another coaching. So when you write your story, you must avoid the term joint investigation because the minister doesn't like it. And then on 114, I'm just taking selected spicy parts. At 114 in the middle, it says, I'm sure that person gone to trouble. I think that's some sort. Then Billy says, be careful how you word it. Avoid sources close to us. In other words, be careful how you source it. Avoid sourcing it to the NPA.
My Lord, I'm sorry to interrupt, but last night when the learned friend telephoned me about arrangements for today, and he undertook that he would be done by 3 o'clock so that we could have an hour in reply. It's now 3:10. He also repeated that this morning. I'm concerned that we are not going to have an opportunity to reply.
Yes, no, that is true, my lord. Firstly, no, I'm not about to finish. It's right what Mr. Padlender has said. Firstly, I had said in the morning that it was our intention to do so. But as I said, that was based on mainly the time that was left. We've already had, I think, the 10 or 15 minutes extra for the tea and another 15 minutes for the lunch. I don't know. Well, I can't. All the counsel in this matter, nobody has been they argued until they finished. Even the amici, they argued or dealt with the matters that they dealt with. I said myself voluntarily this morning that we are going to. I said voluntarily we're going to try, and which is why I phoned my learned friend last night, because there's nothing worse than having a matter not finishing. That's why I called him last night. I said we will try to do it within that period. But I'm not a prophet. I didn't know that will be half an hour.
He said we will finish by 3 o'clock, I promise you. That's
yes.
what he said.
No, that is true. But did I also say the lunch is going to take 15 minutes over and the tea will take 15 minutes over?
No, you didn't
I'm
say
not a prophet.
You didn't say.
All right. All right. So I was on page 114.
My Lord, I do need to record. My learned friend began this morning by saying we argued all day yesterday. We did not. My learned friend, Mr. Badlander Sr. and I finished shortly after lunch. The amici then began, and the two amici supportive of our case ended at 3 o'clock. I checked my watch. That means that there has now been a full day of argument by my learned friend, Mr. Mpofu, supported by my learned friend, Mr. Ngawano. On any fair reading, my learned friend has exceeded his time. And what we cannot, and with respect, this court should not allow, is for my learned friend to filibuster so that we get to the end of the day and this proceeding is prolonged. And we must insist, with respect, that my learned friend indicate how long he needs so that the court can make a ruling. Because my learned friend and Mr. Ngawano have had since 3 o'clock yesterday until 3:10 today. That is a full court day. I beg your pardon. No, and Mr. Ngawano, who was the amicus who began at 3 o'clock yesterday. Because if we're counting amici for their sides, then fine, we finished at 3. And they began at 3. But with respect, it is now more than a full court day.
My Lord, we're just wasting more time to try and save time, which is ridiculous. Firstly, Mr. Ngalwana, the first thing he said when he stood up here was that he's not on anybody's side. Yes. Well, I need the half an hour that I did not know was going to be. Sorry. I'm sorry. I'm just checking my time so that I can give you a proper answer. Now. Okay. No, I thought you said I must stop now.
I didn't say you must stop now. Sit down. If you did not hear me, I could repeat myself. I would gladly do so. I said I ask you to finalize your arguments now, so that we can have the other gentleman reply. I cannot give you a half an hour.
Well, my Lord, that's fine. I'll wind up, as you say. But I just want to record that it's unfair for me to have voluntarily last night called my learned friend and said we're going to try and finish at 3, and on the basis that the normal court hours are going to be kept and that we will start at a particular time. I didn't know that there's going to be half an hour extra that is unaccounted for. Yes, no, I know you've heard me, but I'm putting it for the record. Yes, so it's number one. Number two, no counsel here has been, first of all, no questions were asked from them, and therefore they were able to finish within their time. And don't hear me wrong, I appreciate interaction with the bench, because it's important to if a particular justice doesn't understand or wants to clarify a point. That's not what I'm not complaining about that, but I'm saying that does affect the time as well. So I was assuming that we'll have the normal time and also the same treatment as them. All right. Now, winding up, as I have no choice to. I think if this was meant to take me away from Mr. Soul's Mr. Downer's leakages, well, then it's not going to work. He then says at page 114, be careful how you word it. Avoid sources close to us. That's the leakage. And then at the bottom, I don't have any of those things to come from me. So, yes, this is Mr. Downer. I don't want, or whatever, there's a word missing there. I don't blank any of those things to come from me. Some of the things seem to be to first-hand information, as if he's quoting directly from section 41.6, where it says you may not give information. It must not come from me. They will ask who's talking to the Mail and Guardian. All right? So that is a separate crime, and anybody, even the most biased person, who can say that that does not amount to a breach of section 41.6, then it doesn't know what we're talking about here. Will he be found guilty in the trial? I don't know. But pardon? It did not happen in our jurisdiction. All right. That will take us to section 106 and 110 of the Criminal Procedure Act. Section 106, 1, I think it's that, what you've just said, my lady, is not an answer to the question whether there's a prima facie crime that has been committed or not. Yes, no, I'm just responding. May I? If in section 106, 1H says the following, F, sorry, my lady. When an accused pleads to a charge, he may plead that the court has no jurisdiction to try the offense. Let's pause there for now. So, even if that what you've just said to me was correct, and even if this was a crime that's attributable to a particular city, thanks, that would be a matter to be raised at the beginning of the trial before the criminal court in terms of section 106, 1F. Secondly, section 106, 1F is the only exception to the rule. You look at section 106, 4. Yes, 106.4. You know, I'm sure the court knows, as I've been told, that 106.4 can result in an acquittal. the only exception is if jurisdiction is raised. It says, an accused who pleads to a charge other than a plea that the court has no jurisdiction to try the offense, or an accused on behalf of whom a plea of not guilty is entered by the court shall, save as otherwise expressly provided by this act or any other law, be entitled to demand that he be acquitted or convicted. What that means in simple English is that any other plea in 106 except the plea of jurisdiction is what we call a plea in abatement. In other words, it can be fatal. But a plea of jurisdiction is the only exception because it's dilatory. In other words, it doesn't mean you go away. If by some reason I take you and charge you in the Northwest where you did the crime in Durban, it doesn't mean you're going to get away with it. All that will happen is that the matter will be moved to the correct jurisdiction. And for that proposition, you must go to section 110 of the Criminal Procedure Act. Section 110 of the Criminal Procedure Act says, where an accused does not plead that the court has no jurisdiction and it at any stage, after the accused has pleaded a plea of guilty or not guilty, or whether the accused has pleaded any other plea, and so on, and it appears that the court in question does not have jurisdiction, the court shall, for the purposes of this act, be deemed to have jurisdiction in respect of the offense in question. And where an accused pleads that the court in question has no jurisdiction and the plea is upheld, the court shall adjourn the case to the court having jurisdiction. So, in terms of section 106 and 110 of the Criminal Procedure Act, to whether the thing was done in Durban and or in Cape Town and what, the two things will happen. A, it must be raised. If it's raised, the court will be deemed, this court will be deemed to have jurisdiction. We'll argue it at that stage when it's raised in the criminal trial. B, if we don't succeed to say this court must assume jurisdiction, then this court will act in terms of section 110(2) and transfer the matter to Cape Town or wherever he says he was. It will be raised in the criminal trial. That goes to our jurisdiction and prematurity point. But B, assume I'm wrong on that. Assume it can be raised here. So what? It's dilatory at best. It will either be heard here or in Cape Town. Okay. Anything else about the issues? So that after that they ran out of lane, so to speak, because those are the only objections, except of course the one that I have to deal with in a hurry now, which cross both of them, the so-called Stalingrad. I don't think it's worth the paper it's written on, except to the extent that I have to say this. Remember that in the Zuma case, in the SCA, we were accused here unfairly of having read the case in NDPP versus Zuma and stopped where it suits us. And because we are such, untrustworthy people, just without even talking. We were even asked to apologize, which we are not going to do, about stating that Mr. Downer is aided and abetted by his friends. Some of them, as Mr. Masuku said, at least some of them have come up to masquerade as his friends, but others not. And we're not going to apologize for that. Because Mr. Badlander should know better. He's the most senior person here. He knows that what he did is not done. You don't do that for the cameras and stand up here and say your colleagues must apologize. We're not his children. So he knows that the rules are very clear. If there's any problem, that Mr. Badlander, anyone, either Mr. Badlander, if I see that there's a problem, I have a duty, professional duty, to raise it with them. It's in the guidelines of the LPC. And then to raise it here. I can't just stand here and demand an apology. What apology? It's not done. It's wrong. And it's unprofessional. But anyway, apart from the fact that whatever I was supposed to apologize for is not a matter of apology. We are representing a person here. We're not representing our jackets. Every document you see here has been sanctioned by our client. We painfully do that, even though he's in the middle of nowhere. Make sure that all the documents, he has looked at them because of his status in society. Anyway, it is said that in the safest place to get this, my lords and my lady, is in Mr. Ngalwana's heads at page 3. It's the case we all know, the case of NDPP versus Zuma. But you'll see why I'm using this, because Mr. Ngalwana has quoted the paragraph that we all quote, and then he also quotes the one who are accused of hiding. So, paragraph 37 of the judgment of Haram's DP says, a prosecution is not wrongful merely because it is brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent, something not alleged by Mr. Zuma and which in any event can only be determined once criminal proceedings have been concluded. Hallelujah. That's what we've been saying all day. It can only be determined at the criminal proceedings, but in any event, it is if there are no probable grounds. I've read from Mr. Soul's conversation, I've read from the affidavit, I've read from the emails to show that this is not a case where you can say probable grounds for prosecuting are absent. By any stretch of the imagination, no person can say that. And it says the motive behind the prosecution is irrelevant because, as Schreiner J.A. said in connection with the arrest, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. That's our law. And we were told that we stopped there because we are probably also, we look guilty. We didn't read the next paragraph. Well, the next paragraph is on the next page. This is where it says this, paragraph 38. This does not, however, mean that the prosecution may use its powers for ulterior purposes. To do so would breach the principle of legality. The facts in Highstead and another whatever, the police had confiscated machines belonging to Highstead. The object was not to use them as exhibit. They had enough exhibit, but to put Highstead out of business. In other words, the confiscation had nothing to do with the intended prosecution, and the power to confiscate was accordingly used for a purpose not authorized by the statute. This is what ulterior purpose means in this context. That is not the case before us. In the absence of evidence that the prosecution of Mr. Zuma was not intended to obtain a conviction, the reliance on this line of authority is misplaced and was the focus on motive. This is exactly what we're saying, that unless you can show that Mr. Zuma has no intention of securing a conviction for all these crimes perpetrated against him, and the sole purpose is the so-called ulterior motive, then you can, that's what the court said. Why would we not read this, bad as we are, when it actually assists us? And secondly, that qualification, even if it applied here, would not apply because this is a private prosecution. The principle of legality, which is to do so would breach the principle of legality. The principle of legality applies to public bodies. And we were told, wrongly in my respectful submission, but that's a matter that will be determined by the Constitutional Court, because we have appealed that judgment in Gauteng directly to the Constitutional Court. That's how strongly we feel about it. But in that case, here, well, I don't have to hand it up. Your Lordship said you've got it. In the Gauteng case, you'll remember that it was said there that the reason why it's called a private prosecution is exactly because it is private, and therefore the outer principle does not apply. So when it's President Zuma going to the Gauteng court and saying, they want to stop my prosecution, but to do so, they must pass the outer test, because they are actually reviewing. They say, no, but outer test, who do you think you are? You are just an individual. Outer test doesn't apply to you. Let's go. The president cannot come. But here, he's now told, no. The principle of legality applies to you. What is that? What is that? It is not justice, at least. It's Zuma law. And we're not here for that. We're here to ensure that the same standard, the goddess of justice, must be blind. And if we're going to have justice that has eyes here, that determines who is the accused today, who is the prosecutor today, and then the law changes according to that, then woe unto this country. And you know, the members of the public are not stupid. Members of the public know when there's an injustice. They know it. They might not have gone to university like me and my learned friend, Mr. Masuku, and everything, but they know when there's an injustice. When somebody is incarcerated without having stood in a court of law to say, am I guilty or not guilty, then they know. They say, this far, no further. Anyway, at paragraph, yeah, well, at page 162, sorry, my lord. I'm sorry, my lord. I'm trying to fight fires here. Yes, my lord. I'll come to that. Let me just make this one point. I won't even read. I'm just making a reference. If the court can go to page 162 of the Maughan documents. Is it? Okay, let me just make sure. Sorry, my lord. It's 162 of Downer, of the Downer document, yes. It says, it's just the exchange, and I'll just read it. I'm not going to develop it in the same spirit as the conversation with Mr. Soul. This is the email exchange on the day in question, when the crime was committed. Sorry, I say email, WhatsApp, yeah. Mr. Breitenbach, I hope you are well and aren't en route to PMB, Peter Maritzburg. That's at 1639. I'm here, 1642, that's Ms. Maughan. 1644, 2 minutes later, boom. He sends the Kun J letter of August 2002. There's nowhere where Ms. Maughan says, I request a document, all the lies that I was told in this affidavit, that she made a request for documents. Sends Kun J letter. 1646, he sends the Zuma postponement affidavit. And then in the morning, 7:29, sends our affidavit. And then at 7:30, she says, thank you. And then she says, when can I publish this? And then he says, it was emailed to the judge's registrar and the parties last night, so you can do so now. That's what's called knowledge of unlawfulness, mens rea. So he says, because it was emailed to the judge's registrar and the parties last night, and this one was signed, you can do so now. It's wrong in law, but at least it's an attempt. And then she says, thank you. And she says, great. And then she says, I need to wait before I file on Billy, though. In other words, this file now is about filing the story. So she has to wait on Billy before she can file the story. So the story is written on the criminally obtained information, but she has to wait for Billy. Then Mr. President says, I'll check with him. If that's not an act of association, nothing ever will be. And remember, he had been told before. And he says, please, otherwise it's just their side. In other words, I'll only be publishing theirs. And Tusini refers to Billy's affidavit. That is leaking information that is in your possession in terms of the NPA Act. And it is a crime in South Africa until that statute is changed. What I will do, no, I have to say this. The Ms. Maughan says that they have two ulterior motives. Ms. Maughan's ulterior motive is that Mr. Zuma wants to harass and intimidate her from reporting. She's reporting, she's been reporting, as Mr. Masuku said, ever since 2021. I don't know what intimidation. She writes every day on Twitter about Mr. Zuma. Nobody has done anything. The worst thing that she alleges is that somebody called Mr. Manyi, who is the spokesperson of the J.G. Zuma Foundation, not even in that capacity, as himself, as Mr. Manyi, just walking in the street, sent a tweet, and Ms. Dudu Sambutla Zuma also sent a tweet. I mean, really. So, former President Zuma must now go around controlling everybody out there, spokespersons and children, about what they tweet. I don't even, he is on Twitter. I was going to say, I don't even think Mr. Zuma is on Twitter. But to the extent that he is, he's not his daughter's keeper. None of us can be imposed with that silly obligation. So there's no intimidation, there's no... Mr. Zuma says, Aigabi, as we say. He says, I don't know the lady. I do not know this Karyn Maughan. In fact, he was saying to me, even if she came there, I wouldn't be able to point her. So how can I resent her as someone that I don't know? I was told, I saw this thing and I was told that somebody is doing rounds with my information and so on, my medical information. I don't know the person. So this idea that by osmosis, whatever resentment might happen to anybody on Twitter must be attributed to President Zuma is just plain nonsense. Then the other Stalingrad version now of Mr. Downer is that, no, it is to get rid of him as a prosecutor because of the so-called 20 years Mr. Zuma has been evading. I don't know how I describe that one. Firstly, there's no 20 years. The so-called 20 years that gets bandied about, we allow this thing to happen because, the media has got its own mentality. But in a court of law, you can't come and talk about the 20 years. There's no 20 years. The charges were withdrawn in a particular time. For 9 years or so, there were no charges, and then they were reinstated in 2018, I think, yes. So they count even the 9 or 10 years when there was nothing into this so-called 20 years. And then they lie and say that Mr. Zuma, in all that, has been unsuccessful in his matters. Well, that's also false. Mr. Masuku has told us that Judge Msimang in this court said that this was politically motivated. Judge Nicholson in this court said that it was politically motivated. But if the answer is going to be, well, okay, they might have said so, but eventually there was an appeal and so on. But I'm just saying judges, sober judges of this country have held in Mr. Zuma's favor. But let's forget about all that. Justice Kuhn, here, sitting here last year on the 11th of April, when we wanted a postponement pending a constitutional court appeal, the other side came here and argued Stalingrad. Justice Kuhn rejected it and granted the order in our favor to await the outcome of the constitutional court, and rejected with the contempt it deserves, those are my words, he didn't say it himself, the so-called Stalingrad accusation. So people can go and manufacture their own facts out there, but this is a court of law, this is a serious place. It's not a place to come and bring gossip here and twisted spin. So there's no Stalingrad. If there's any Stalingrad, they are guilty of Stalingrad. Because as the Stalingrad is either the myopic version that gets described by the chartering classes out there, or the version that was described in a court of law by Wallace J.A. at paragraph 157 of the Moyo case, where he says Stalingrad is the tendency of well-to-do, well-resourced accused persons to escape the consequences of their actions in a criminal court and go to a civil court. That's Stalingrad. That's what they are doing. That's why we're here. They should go back, like all the people in this country, black and white. When they are served with a summons and they say, go to court on Monday, the criminal court, they take their things. It doesn't matter if they think that they are innocent. They go to court, they run the trial, they win or lose. What's so special about them? Why should they not deal like all the millions of accused persons every day in our country and come here and have 3 judges at their request in a civil trial listening to all this, instead of doing that which every South African is obliged to do? Forget about every South African. Former President Zuma. Mr. Downer says he's a prolific litigant or whatever, says that as a snide remark. No, it's not a snide remark. It's a badge of honor. Because unlike some, former President Zuma, for all the years, for every time he's here, day in, day out, if he has to be there in the dock, he's there in the dock. If he has to be sitting here, he's sitting here. He has never sheepishly run away from appearing in a criminal court of law. He is here. He's a former president. He's not you and me or you know. He's a former president of this country. But he comes here dutifully. If he's going to be sick, he sends a note. And for years and years, he's been doing that. But no, not Ms. Maughan, not Mr. Downer. Let's be serious, man. If we want a country here, let's make sure that we have a constitutional democracy that respects the rights of every citizen, black or white, in the same way, and nobody should have some special dispensation of a civil court. That is what is Stalingrad, as described by Wallace J.A. in paragraph 157 of the Moyo case. And therefore, with the greatest respect, for the reasons that I've explained, I don't have time. If Your Lordship, maybe just to, if Your Lordship can allow us to, because there are 1 or 2 points, maybe to file a short supplementary submissions on the 1 or 2 points. Yes. Thank you, my Lord. As the court pleases. I'm indebted to the court.
Lord, could I have an indication as to how long we can argue? Because I will not be done in 15 minutes, and I'm afraid that what has happened here is that my learned friend Mr. Mpofu has argued from 9:30 until 4:45. That is in excess. That's approximately 5 hours without breaks. My learned friend Mr. Budlander and I argued yesterday from 9:50 until 12:30. That's 2 hours and 25. But with respect, my Lord, my learned friend Mr. Mpofu is not entitled to disentitle my side from a proper entitlement to reply. Well, my Lord, in that case, we ask for leave. I can't speak for Mr. Downer, but we ask for leave to file our note in reply. Because with respect, there are points that need to be dealt with. There are arguments that have been made that are entirely without merit, and I would ask that we have permission to use the 15 minutes to go, and that we are then entitled to file a note in reply to Mr. Mpofu's address. That is, I make that request. Alternatively, I ask that you request that the court staff sit late. I make one of those two requests, my Lord.
That's, with respectfully, I respectfully adopt the same position, my Lord. We really, it would be entirely unfair for us to be denied the right to reply.
My Lord, sorry, just a few remarks now that if that will be the arrangement.
No, with respect, my Lord, I did not invite my learned friend to address you again. I asked for the 15 minutes to address you, following which I would deal with the balance of the points in reply. And for him to suggest that he's now going to make further submissions is, with respect, wholly unprofessional.
My Lord, thank you. 2 minutes.
Of course, just in case. First prize is for you to get 15 minutes. Right, Steve. All right. very grateful for that.
We are most indebted to your lordship, your ladyships, and indeed the court staff. Thank you.
Yes, my lord, I was on my feet, but Mr. Badlander chose to insult me. I was still on my feet, and he says my wanting to speak is unprofessional. It's fine. We'll tolerate these things up to a point. I just wanted to say that I don't want to be waylaid by that. To just say two things. One is Mr. Badlander Jr., at least, Mr. Badlander Sr. is not involved in this, knows that this very thing that happened here happened in a matter where he was my opponent last month, and we couldn't finish a 2-day matter, and we had to come on a 3rd day. And that was arranged. Fortunately, he had finished, and his junior. No, my lord. No, it does. No, my lord, I've been insulted. Your lordship cannot allow. I was told, firstly, that I'm filibustering, number one. And now, secondly, I've been told that my wanting to address the court is unprofessional. If your lordship wants to silence me in the light of those insults without giving me a right of reply that everybody who is insulted in this country has, then I will sit down. But I thank you very much. Yes, well, my lord, I was insulted in this forum. I'm simply saying that if I was told that I'm filibustering, the court did not intervene, which the court should have done. And the court did not intervene when it said that when I want to address it, it's unprofessional. Then what other forum am I going to address in? Well, my lord, I'm sorry. Sorry, my lord. Yes, no, that's fine. I just want to place on record that I did not filibuster and I did not act unprofessionally. And if anybody feels that I did, they, not me, must go to the appropriate forum. As the court pleases.
Thank you, my lord. My lord, I have agreed with my learned friend from Mr. Downer that I will argue first, and we will ensure that we do not repeat each other, and we will ensure that we complete within an hour between us, even if I take 5 or 10 minutes extra. My lord, my ladies, what you have been treated to is, with respect, a spectacle, because you've had to witness our learned friend from Mr. Zuma accuse this legal team and the other legal teams of lying, of being disgraceful, of being arrogant, of bigotry, of obfuscation, and of subterfuge. And I'm afraid that it became clear what was going on in 2 answers. When at one point your lordship presiding said to our learned friend for Mr. Zuma, we know what the law is on private prosecutions, and
to address them at the end. The submissions we made were aimed at the litigants. We never said anything about counsel, but were available if there's going to be that kind of insults. We're not going to be abused here.
well, look, my learned friend took my next words out of my mouth. What I was about to say is that we are going to resist the temptation to respond likewise. We are going to do what we understand is our duty. We are going to focus on the facts and the legal principles at hand. Because with respect, when you focus on the facts and legal